Without much ado, I would like to now turn the floor to Signe Grīnberga, Project Working Group member and the President of the Latgale Suburb Court of Riga City. Good afternoon, dear colleagues. It is indeed a pleasure for me to see so many of you after the lunch break. And my task, as a moderator already mentioned, was to introduce to you the theoretical and practical considerations of the other framework decision. Croatian and Lithuanian colleagues and Belgian colleagues also shared their experience with respect to the framework decision before lunch, and I suppose that I have to now cheer you up after lunch so that you don't fall asleep after having a hefty lunch. So I will try to keep it interesting, and we'll split it into 4 blocks. I will start with theoretical and practical aspects, and we'll split it in 4 sections. I'm a first instance judge. I've been adjudicating for 12 years already, mostly working with criminal cases and international cooperation and recognition that we are responsible for as a court involve a lot of paperwork. We don't have any Hollywood Con Air type stories to tell. We are mostly working with papers, managing papers, processing papers, and are not really involved in any enforcement actions. And I am indeed the project working group member, and I've visited Lithuania in 2019 in September, and I can see on screen a couple of colleagues, a couple of familiar faces. So hello, greetings to everyone in Lithuania. It's nice to see you again, by the way. And it was nice to also visit you in person to exchange the experience with Lithuanian and Croatian colleagues and talk about how we apply mutual recognition systems. So we exchanged our experience on the application of this framework decision, on the application of the mutual recognition to judgments and preparation decisions. And we, as has been mentioned, created the case law compendium or collection, as has been mentioned, with Croatian and other colleagues. We had Lithuanian colleagues. We had to work remotely on finalizing of this compendium or case law collection because, unfortunately, due to COVID, we could no longer meet face to face. Nevertheless, this compendium is another support tool to judges, assistant judges, and central body staff, lawyers, and other legal professionals that are dealing or handling these requests on daily basis. And as I already mentioned, I've divided my presentation in 4 parts, 4 sections. I should tell you right away that I'm not really a seasoned professor, so I'm not really used to be speaking in front of audience, especially international audience, so please bear with me and don't be too harsh in your judgment as regards to my delivery. So I will start with the key elements of the framework decision and the transposition of those key elements into national legislation and the activities that an executing country must implement. I will talk about the challenges and possible solutions to the application of this decision, and as a merit of a reminder, I see a lot of people who are very much familiar with the framework decisions and the challenges and theoretical application. Nevertheless, would like to again remind you, because this is very valuable, would like to once again remind you what are the key objectives of this decision. So, decision was drafted in order to provide the opportunity to a sentenced person to serve their conviction in their home country and thus more successfully reintegrate into society. So the objective is to ensure social rehabilitation of sentenced persons, improve the protection of victims and population as a whole, and enforce more efficiently sentences to individuals that are not permanently residing in a specific member state where the offense has been committed, as well as ensure mutual recognition of penalties by providing opportunity to serve the sentence in your home country, reintegrate into society, keep your family, language, culture, and improve the efficiency of the probation monitoring and avoid repeat offenses. Decision stipulates the basic requirements that a member state where a person has been convicted must comply in order to transfer the sentence and the probation decision to the member state where a person has been lawfully residing permanently, and thus enforce this judgment in the member state and oblige this member state to supervise alternative measures or probation services. And each member state has designated its competent authorities that are responsible for the enforcement of the framework decision in cases when it is either issued by the member state in question or needs to be executed by the member state in question. So the implementation of the framework decision 2008-947 of 27th of November 2008 came to force on 16th of December 2008. According to the Council framework decision, the European Union made sure that all countries are ready to implement the requirements of the decision by 1st of July 2012, and we made or transposed the decision on 4th of May 2012, which came to force in July 2012. According to the amendments, if Latvia executes a alternative sentence issued by another member state, or if it requests other member states to apply alternative conviction, we have to follow the framework decision. And it is the 16th and 17th chapter of the criminal procedure law. As regards to Lithuania and Croatia and how they transposed the framework decision in their national legislation, we already heard about that from our Lithuanian and Croatian colleagues, so I will not repeat the information and will skip it. So let me now mention the definition of the competent authority. According to Framework Article 3, each member state must inform the Secretary General about the designated competent authorities that are responsible for the enforcement of these sentences as executing and issuing countries. In Latvia, it is the town or district court that is responsible for the enforcement, whereas the central body for coordination is Ministry of Justice. Framework decision also determines that each member state must inform the Secretary General of the Council on the probation services and alternative measures, except for the measures mentioned under the Article 1, are under its supervision, and Latvia has only recognized those probation services that are stipulated by Latvian criminal law. We also had to indicate the language in this declaration, had to declare the language, and according to Latvian declaration, we are accepting documents in Latvian. As regards to cases when Latvia is the issuing country and has asked other member states to recognize its alternative measure, what should we do? If the court decision on alternative sanctions is not applicable because a sentenced person has requested the return to another member state where they permanently reside, first instance court should send the judgment and the form to the Ministry of Justice. According to the judgment and national legislation of Latvia, this judgment can be also enforced together with a prosecution penal order issued by a prosecutor. So together with the form, you send the judgment, the translation of the form. You also inform of the statute of limitation applicable to the particular kind of offense and send the information to your counterpart in another member state, and Ministry of Justice can send the certification only to one member state at a time. And during the working group meetings, we studied how this is applied in practice here in Latvia, and we found out that not all courts are filling out the G1 section of this form. They are not providing full and complete information about the circumstances of the offense, the legal qualification, and other details about the offense. For example, this form should contain a reference to a specific article of the criminal law, and J4 aisle should also be filled out very fully as regards to the probation services applicable to the person. And if necessary, court can also be requested to provide additional information as regards to the obligations of the sentenced person with regard to the probation service or probation period, request to add additional information to the form, and any other additional details.
If a request has been sent on enforcement of alternative sanction in another member state, and if consent of this member state has been received, then the Ministry of Justice informs the applicant and the court which controls full enforcement of the judgment, the sentenced person and the representative, if this representative has submitted the request. Upon receiving information from another member state that the sentence has been served, the Ministry of Justice informs the court about it, and also the institution where the sentence had to be served. And again, looking at the cases which the members, which the working group had at their disposal, we see that often other member states do not provide information about enforcement of Latvia's probation measures, and accordingly, what the Latvian courts should do, they should control the course of enforcing probation measures. For example, if information has not been received for a longer period of time from another member state, the Latvian court should send a reminder to another member state requesting information about the course of enforcing the judgment. Now, if Latvia is an executing state which has received a judgment from another member state, to recognize and enforce it in Latvia, the following is needed. First of all, this decision by the competent authority of the EU member state on alternative sanctions, and also the certificate, and also the fact that the person to whom this alternative sanction applies resides in Latvia permanently and is in Latvia. A decision by the Latvian court on determining the alternative sanction to be enforced in Latvia. And Latvia recognizes and enforces the ruling regarding an alternative sanction, even if the person is not residing permanently in Latvia, but has indicated its place of residence in Latvia. If the person has employment relationship in Latvia, family relationship in Latvia, or if the person is obtaining education in Latvia. And the reasons for refusing to enforce this decision on alternative sanctions: if the certificate has not been sent, or is not complete, or does not comply with the content of the decision, if this offense is not included into Annex 2, or is not an offense according to Latvia's law, if the person does not have permanent residence in Latvia, or if the person cannot be reached in Latvia. And if the principle of ne bis in idem would be violated if this decision would be enforced, and if this alternative sanction applies to offense which according to Latvian law is not an offense, and if the criminal procedural immunity exists, and if the limitation period has set in, and the decision on alternative sanctions applies to an offense which is within Latvia's jurisdiction, and if the person has not reached the age when criminal liability sets in, and if the alternative sanction does not exceed 6 months, or if the decision on the alternative sanction envisages medical treatment, which would be impossible to provide in Latvia. And upon receiving this decision from another member state, the Ministry of Justice the ministry within 10 days. But if in 30 days, if the case file is very large, then the ministry examines the materials, and after that, it sends this decision together with all the materials in the case to the court and informs the other member state of the EU about it. The judge of a district court within 30 days examines this request in written proceedings. And then the judge decides, having assessed also this request and perhaps the reasons for refusing recognition. If the information provided by another member state is incomplete, the Ministry of Justice or the court, with the mediation of the Ministry of Justice, can request additional information and document and setting the date by which this should be provided. This decision is not subject to appeal, and the judge informs the other member state about it, and the sentenced person about it. And also with the mediation of the Ministry of Justice, the other member state. And also the sentenced person if the person is in another member state. The court adopts this ruling in written proceedings, and before that, the court sends to the sentenced person and to the prosecutor information about the right to submit objections within 10 days, counting of the date of receipt, object against enforcing alternative sanction in Latvia. And also the prosecutor can submit the opinion. And when the judge adopts this decision on determining the alternative sanction to be applied in Latvia, and then forwards this decision for enforcement, and the person to whom this alternative sanction applies is informed, as well as the Ministry of Justice and the competent authority of the EU member state. What are the problems that are in those cases when the issuing state is Latvia? Our court encountered one case. It was a conditional sentence. And the person was, well, the ruling was that the person should not reoffend. And the Supreme Court forwarded a question for preliminary ruling to the Court of Justice of the European Union. And the question was as follows: whether applying the principle of recognition to such decisions and probation judgments regarding alternative sanctions, whether it's enough that only one legal obligation is indicated, not to reoffend during the probation period, because the Supreme Court of Estonia believed that this obligation did not comply with any of the probation or alternative sanctions indicated in the framework decision. And so that's why the Supreme Court held that this decision could not be recognized and enforced. And the court, providing the preliminary ruling, indicated that from Article 2 of the framework decision, it followed that probation measures are obligations and orders which have been linked to a conditional sentence, and the sentence had been given by the court. And since the framework does not state that only certain measures can be qualified as probation measures, so the obligation not to reoffend during the probation period can be recognized as being a probation measure, because this is a condition for suspending custodial sentence. And although this obligation not to reoffend is not directly mentioned in Article 4, which lists all the obligations and categories of orders, the reference to the category orders pertaining to conduct, in the court's opinion, this is a concept which has been defined in the framework decision. I do apologize, it has not been defined in the framework decision, but facilitates reaching the aims of the framework decision, and also facilitates social rehabilitation of the sentenced person, improves the protection of the victims and society in preventing reoffending. So the court answered and provided the preliminary ruling that these articles should be interpreted to mean that recognition of such sentence that has given a custodial sentence, which has been suspended only on the conditions that the legal obligation not to reoffend during the probation period falls within the scope of application of the framework decision, if this legal obligation follows from this judgment or is based on this judgment and on the probation decision adopted on the basis of this judgment. If I have any time left, I will speak briefly about problems and solutions connected to the framework decision, all the problems that we have encountered in Latvia. And I've heard that also Lithuania and Croatia had to deal with similar matters. To facilitate cooperation, both the issuing country and the execution country, they need, they have to communicate in different stages of the procedure when requesting information or facilitated exchange of information. And as I just mentioned, this Estonian example, Estonia had requested information from the Latvian court about certain data of the person, which they considered as being incomplete, but information about probation measures, what the court had intended by it, and which are included in the Latvian Penal Code. What Estonian court had not requested this kind of additional information from Latvia. And I believe that if they had requested this additional information, we wouldn't have to wait so long for this preliminary ruling and the opinion given by the Court of Justice of the EU. And there's this form of information exchange. In practice, at least in Latvia, we observe that we communicate in writing, so in paper form, we send different requests. And this really takes time. It's time-consuming until we receive this information in the executing state. And the email should be used, I believe, to make this communication more effective, rather than have this exchange of information in written paper form. And about now, regularity of information exchange. We have observed in Latvia that communication is not always regular, and that we are not receiving answers, timely answers from all involved parties. And if we don't receive the answer in time, my proposal would be that we should write these reminders, remind of this request, and also perhaps change the communication channels. Perhaps we should move to e-communication. While studying these cases from Latvia, Lithuania, and Croatia linked to enforcement and takeover, we see different forms of registration. We register these cases with the ministries, or we register with the courts, and apparently this somehow causes some kind of disorderly system. I believe we should have one digital format that would really speed up the communication, and all these cases would be found in one place. And it would also give the possibility to summarize case law and to analyze the case law, and also to collect statistical data.
Previous speakers already referred to the quality of translation. I would also like to briefly touch upon the quality of translation. Indeed, we see quite often that the translation of documents are very poor, which delays the efficiency of the proceedings. So what should court do if it is detected that the translation is of low quality? You can indicate to the providers of the translation that the quality of translation is below desired standard. You can request them to improve the translation and meet the standards of legal standards of these translations, or also request the parties to the trial to extend trial deadlines. And by the way, translators can also use the framework decision translations in all languages with all the annexes, and you can use them. If you have to translate this documentation, I can also send you the links if you need. So that's all in a nutshell from me as regards to framework decision. Thank you. Does anyone have any questions to Signe? If you have a question, just unmute your mic and you can ask the question then. We don't have any direct question. Oh, we do. Yes, Signe is also available for answering questions in writing as well in the chat box. Do we have a question? Yes, please, Petra.
Very interesting presentation. Just one question, because you were proposing to get to more email contact. Do you have any problem with data protection or secure ways of email communication in Latvia? Is it an issue in your country?
Vai tā ir problēma sūtot pa e-pastiem šos dokumentus nevis rakstiskā formā, kā ir atrisināt, un vai tā ir problēma Latvijā, kā ir atrisināt drošības jautājumu, kā šie, varbūt arī droši vien jautājumi.
Just translating the question. Well, as far as Latvia is concerned, we have put all the safety measures in place. You have certified digital signature that judge uses to sign the documents, but that's as far as formal correspondence is concerned. But sometimes you need, just to find something out, a minor detail, a minor nuance, something that is not confidential, something that you can just, ask in an email, not something serious that could be used against any of the parties or any of the those who are involved either in sentencing or the implementation or enforcement of the sentence. But we have, secure digital signatures. So everything is safe. There's nothing wrong with that. And we have all the IT security and protection frameworks in place in all of our public administration. Any other questions? Thank you for your attention.